the Supreme Court of Fiji, in its original jurisdiction, miscellaneous section number 1 of 2025, in the matter of section 91, subsection 5, and section 98, subsection 3C of the Constitution of the Republic of Fiji, in the matter of a reference by Cabinet for an opinion from the Supreme Court on a matter concerning the interpretation and application of sections 159 and 160 of the Constitution of the Republic of Fiji.
Okay, representation for the state.
With pleasure. May it please this honorable court, my lords and my lady, it is my humble duty to introduce the state's councils this morning for the referring party cabinet, Attorney Turanga S, Solicitor General, Green R. We appear with the King's Counsel Walker B, Assisting Counsel KBN, will be delivering the state's oral submission. Thank you.
Thank you, Mr. Turan. Next intervener.
It pleases the court, my lords and my lady. Counsel's name is Simeone Valnitambo, and I appear for the People's Alliance Party in this matter.
Thank you, Mr. Valnitambo. For the National Federation Party.
Please the court, my lords and my lady. Counsel's name is Active, initial J, and I appear with my colleague, Mr. Naidu, initial R.
Thank you, Mr. Apted.
Beg your pardon, my lord.
For the SODELPA.
May it please the Lord, my lords and my lady, Counsel's name is Ulundole, initial J, and I appear for SODELPA.
Thank you, Mr. Ulundole. For Honorable Seruratu's faction in Parliament.
Please, Honorable Court, my lords, my ladies, my lady, Counsel is Singh, initial K, and I appear for the fourth intervener with my co-counsel Chand, initial P.
Thank you, Mr. Singh. For Mr. Honorable Naivalaru's faction in Parliament.
Good morning, Your Lordships and Your Ladyship. Councils are Vakalalamure, initial T, and Davy S. We appear for the G11, led by the Honorable Mr. Naivalaru.
Thank you, Mr. Vakalalamure. For the Fiji Labour Party.
Please the court, my lady, my lord. I appear for the Fiji Labour Party, Council's name Karnaratna, initial J, together with Council Nandan, initial S.
Thank you, Karnataka. For the Fiji Unity Party.
May I please this honorable court? Counsel is Rekadi, initial N, and together with me is Ms. Bulivao, initial L, and we appear for Unity Fiji Party.
Thank you.
Thank you.
Thank you. For the Fiji Human Rights Commission.
May it please Your Lordship. Counsel's name is Alafinabuki, initial V. I'm also a commissioner with the Human Rights and Anti-Discrimination Commission. I am assisted by co-counsel Kini Willi, initial V. She's also the director of the Human Rights and Anti-Discrimination Commission. Thank you.
Thank you, Ms. Vuki. For the Fiji Law Society.
Yes, if it pleases the court, my lords and my lady, counsel is Moses, initial A, appearing with Professor Kaiser, initial P, and Mr. Clark, initial W. Please.
Thank you, Mr. Moses. The counsel assisting the court.
Nisi Andra Vinaka. Counsel's name is Butler KC, initial A. Amicus curiae, so a friend assisting the court.
Thank you, Dr. Butler.
And Your Honour, as you know, I'm assisted today by my law clerk, Ms. Pridgeon of the New Zealand bar. She's not admitted in Fiji, but the court has been very kind to let her assist me today, so much appreciated.
Thank you. Well, we'll now now start with the proceeding. I understand the state is given 1 hour to present their submission. Judges are entitled to ask questions during the submission for further clarifications. Thank you. Over to you, Mr. Walker.
Please, the court. The court will have seen in the court book at tab 38 a bill for an act to amend the Constitution of the Republic of Fiji. Those voting in favour of that bill on the 11th of March this year were 40. So a majority of 40 of the 55 members of Parliament. Obviously, 40 is much more than a simple majority. It is more than a 2/3 majority. It is just 2 votes shy of a 3/4 majority. The body of the bill, with which Your Honours are familiar, has as its substantive effects upon the amendment, were it to be enacted, the removal in particular of the referendum requirement, with, as it happens, its 3/4 majority, for amendments of the Constitution that are permitted by the Constitution by provisions to which I shall shortly come. However, as you will appreciate, that bill on its face was presented notwithstanding the provisions of section 159, subsection 2, paragraph C, which is at the heart of the argument, and to which provision I shall again come shortly. This reference arises from the Cabinet being conscious of the possible legal controversy, probably made manifest by the number of counsel in the court, arising from the interpretation and application of sections 159 and 160, and thus the Cabinet resolved to seek the opinion of this court as a demonstration of its intent to have an open, ordered and respectful manner of vindicating the Cabinet's view on the true position concerning amendment of the Constitution's own amendment provisions. The background, the foundation of the way in which the issue is presented and the state says ought to be decided comes as follows. There are 2, at least, fundamental features of the Fijian polity reflected in its constitution in provisions to which I shall later come. And they may be described as, first, democracy through parliamentary government, that is, free and fair elections with an appropriate franchise and equality of votes. And second, the rule of law given effect by judicial enforcement, that is, by courts of law, conducted in an independent and impartial manner. Now, those 2 features are not the only features that characterise the means of self-government of Fiji that might be called, as a matter of political science, a form of popular sovereignty. I shall come later to provisions of the Constitution that make that explicit. It follows fundamentally that self-government in a democracy must involve the people from time to time, periodic elections, for example, and then including by the actions of their democratic representatives, those whom they elect to represent them in Parliament, changing the provisions of their constitution, that is, their supreme law. it is a contradiction of democracy understood in that ordinary way, and it is certainly a contradiction of the dignity of the individuals who are the voters from time to time, to deny the body of voters, those of the people with political rights, to deny those voters the capacity to alter any existing provisions of the law by the means constitutionally provided in that regard. Parliament, the state says, as it demonstrated by its introduction of the bill that attracted 40 out of 55 members of Parliament in support, Parliament, says the state, is the organ under the Constitution for law making on behalf of the people. And thus it is Parliament that can bring about the proper, non-contradictory position concerning the Constitution's own amendment provisions. The next fundamental matter, which cannot, alas, be polished to an acceptable sheen, is to remember that which this court and the Court of Appeal has noted in previous arguments concerning this or earlier constitutions, that the political history of this country is illustrated most recently by the fact that the 2013 Constitution, the Constitution of which I'm speaking, was not democratically created. And that was true of all constitutions apart from that which was promulgated by the British Crown upon independence, which itself was not directly a creature of Fijian democracy, notwithstanding the very considerable involvement of the Fijian people in its devising. The current constitution and its provisions, and in particular Chapter 11, to which I'm about to come, has never been in any way or in any sense on the ballot in any of the three elections since 2013 for Parliament.
But, you mean directly on the ballot, because some of the parties did campaign against it.
Absolutely. Yeah. That's exactly right. And may I make this clear, to look ahead to a matter, not on the ballot directly, of course. The people were never given choices about the whole or any part of the Constitution, but also not on the ballot effectively in any indirect sense, because the selection of members of Parliament is not, of course, a means in any way of altering the Constitution. This reference before this court is, of course, a form of litigation of its own kind. It's not, in the sense of parties opposed to each other, adversarial, which doesn't mean that the court cannot derive benefit from the dialectic of opposing arguments. But it's not adversarial, and there is no private party interest involved of any kind. We seek the determination under paragraph 98(3)(c) of the Constitution by this court of what is called its opinion on the matters referred to it by Cabinet under subsection 91(5) of the Constitution. The focus of the argument is on the provisions of sections 159 and 160, two of the three provisions in Chapter 11. They deal together with amendments of the Constitution itself, partly to prohibit, partly to permit, and as to those permitted, to regulate the mode of amendment. The focus
of the reference then obviously entails interpretation of the Constitution as a whole. In Fiji, constitutional law, as in many other countries of comparable political kind, requiring the interpretation of all instruments as a discrete entity for consideration by the court, to be conducted by considering the provisions in the context of the whole of the provisions in which they are found. Necessarily, upon determining how those provisions are to be interpreted, the court is then asked to provide its opinion on how they apply. Thus, interpretation and application is, of course, the whole of the exercise that the state respectfully seeks this council to carry out in relation to those provisions of Chapter 11. I'm now going to turn to Chapter 11 itself.
There is the antecedent question which you'll be aware of,
Yes.
as to whether this court has jurisdiction.
Yes. May I make this position clear, and I will, subject to time, elaborate somewhat, but if I may anticipate, this could well be an issue that would best be presented by the state in reply. Why is that so? Obviously, appearing as I do for the state on the instructions of the Cabinet with the Attorney-General next to me, obviously we say the Constitution operates, subject of course to the way in which it operates, which is the burden of our argument. But we say the Constitution operates. To combine a number of questions, that means to use the jargon of political science as it has been absorbed into some aspects of constitutional or supra-constitutional law with which with the court is all familiar. It means, of course, that we submit that, notwithstanding the history of how the 2013 Constitution came about, it is now demonstrably efficacious in providing the supreme law of this country. There are no rival constitutions. There is no government emanating from elections conducted otherwise than under this Constitution. There is a unicameral parliament, not a bicameral parliament, as had formerly been the case. And there is now a completely equal electorate rather than one divided according to various affiliations. So that the
first question is, for us, is whether we have jurisdiction, which depends upon whether we recognise the Constitution as the operative supreme law.
That's why I started with those propositions.
Yes, all right.
Because the glib answer to where is your jurisdiction is in the Constitution. That obviously forces the court to confront, in the history of this country, the question, is the Constitution that I keep referring to, the 2013 Constitution, indeed the supreme law of Fiji? And as you would expect, I hope, from counsel appearing for the state, being counsel instructed by a Cabinet, being entities referred to in the Constitution, of course, we assert and seek to demonstrate from the dozen years and 3 elections and the skeletal features of the polity as conducted under the 2013 Constitution, we seek to demonstrate that they are the only forms of government for the peace and good government of this country which are in currency and in operation, and we submit in a broad sense accepted. That is enough as a rule of recognition or as a demonstration of efficacy. Now, we are not, of course, in any area of discourse such as obtains between state actors in public international law concerning recognition either of nations or of governments of nations by reference to doctrines that travel under the nickname of de facto, etc., etc. We're not in that area. municipally, that is domestically, within and for Fiji, it is manifest from the state of affairs over the last dozen years and the 3 elections that the system of government in this country is governed by, administered in accordance with the 2013 Constitution. There is no rival. That being so, we return to what would have been on its own the glib answer, whereas your jurisdiction looked at the Constitution and say, it is in the provisions that I have just recently recited. It is in the combination of the opinion jurisdiction and the exclusive jurisdiction of this court to give its determination on those opinions concerning interpretation and application of the Constitution that this court derives its jurisdiction. I need to add as well that subsection 2.4 of the Constitution renders explicit that which might be implicit in polities that, like Fiji, distribute state power between arms, legislative, executive and judicial. And it might be that that simple functional distribution on its own, as John Marshall plainly thought in Marbury and Madison, would be enough to assign authoritatively and effectively the power to carry out the duty of the judiciary to interpret all law, including the supreme law of the Constitution. But we have that explicitly here in Fiji, in the very clear commitment to the judiciary at its pinnacle, this court, in relation to matters of the Constitution, by subclause 2.4, referring to the enforcement of the Constitution being the role of the judiciary. And it's in that sense that we say that unless and until something which substantively is able to answer the propositions I've just expressed in answer to Justice French, the jurisdiction of this court is clear and we seek it to be exercised in order to discharge a most salutary function of this court, speaking generally about the constitutional position of this court and speaking specifically about the issues that we present in this reference to the court. In Chapter 11, if I could take your honours to it, please, you will see at its commencement a 3-section chapter concerning the amendment of the Constitution. The following clear statement, which I characterise as dividing the provisions of the Constitution into 2 classes, those that may be amended and those that may not be amended. Subject, it says, to subsection 2, that is, the words of subsection 2 govern the matter, the Constitution or any provision of this Constitution may be amended. And then a stipulation regulating that permission in accordance with the procedure prescribed in this chapter. So the procedure prescribed in the chapter, and looking ahead, that's section 160, is obviously the procedure for those amendments that are permitted. And it may not be amended in any other way, perhaps added for abundant caution, but with irresistible clarity. And I jump over section 160 for the moment to draw to your attention that which is not directly an issue in this case and is now, in a sense, a dead letter. Section 161. It provided for what one might call a period of grace following promulgation of the Constitution, which I stress was not made by resort to any antecedent legal authority. During that period of grace, a combination of those who occupied the role of President, Cabinet, and this court needed to be involved in amendments which would be made by their combination, their cooperation, and which of course omitted any role of Parliament, let alone of electors directly or indirectly.
None were made, I take it.
None was made. None. Those which could have been made would have to have answered the description, according presumably to the reasonable and good faith opinion of those actors, as being, quote, necessary to give full effect to the provisions of this Constitution, or, more frequently for the argument in this case, to rectify any inconsistency or errors in any provision of this Constitution. So that there were two ways to amend provisions, and one can see that there was a relation between them which requires looking at all three sections, even though the third of them, as I say, is now a dead letter. It would appear from the beginning of section 161 that subsection 2 of section 159 did not control it, that is, notwithstanding anything contained in this chapter. But again, that's of no direct moment, not only a dead letter, not only not resorted to, it is not in question in the reference. But I point these features of Chapter 11 out because of the need to observe that it divides the provisions into classes, some that may never be amended and that some that may be, so long as the procedure in section 160 is followed. So section 160, to use the jargon, might be described as a manner and form provision, but it is manner and form of the amendments which are purportedly the only ones permitted by Chapter 11. And that doesn't include, as Your Honours appreciate, any provision of Chapter 11 itself. You see that from paragraph 159(2)(c). No amendment to this Constitution may ever repeal, infringe, or diminish the effect of this chapter. The effect of the chapter can be seen most importantly for the present argument in section 160. We can leave aside explicit titling in subsection 1. We then look to a parliamentary process in subsection 2, and I draw to attention those not because they are directly in question in this case, but because they are of a familiar kind found in other times and places. The striking feature of paragraph 160, subsection 2, paragraph B, is the requirement for support by the votes of at least 3/4 of the members of Parliament. In subsection 3, a bill supported in that fashion is not then sent to the President for assent. The President is to be notified of the event, but the President's position is to refer the bill to the Electoral Commission, whereupon the Electoral Commission is to conduct a referendum for what's called all registered voters in Fiji to vote on the bill. Under subsection 5, the result of that referendum is notified to the President, and if the outcome notified to the President is that 3/4, meaning of course at least 3/4 of the total number of the registered voters have voted in favour of the bill, then the President must assent. And it comes into force accordingly. I needn't dwell on subsection 7 of section 160, which doesn't so much provide for procedure as simply ensures that the word amend or amendment are given appropriately broad and substantive interpretation, not a matter that arises for particular consideration in this case. Now, while I have read through those provisions, may I very briefly look to some of the arguments that you've seen replied to by us in writing already in relation to the nature of the prohibition in 159(2)(c), which is against repealing, infringing or diminishing the effect of this chapter. I don't want to steal their thunder, but as I understand it, the Law Society says that a provision, for example, altering the measure of supermajority required say in Parliament would not be altering the effect of the chapter, because there'd still be a requirement of a supermajority, or at least that's what we understand the gist of that part of the argument to be. With great respect, that cannot be right. One alters the effect of a provision which provides for a 3/4 supermajority by either eliminating any supermajority and requiring a simple majority only, or by either increasing or decreasing the measure of the stipulated supermajority. That's the first matter I'll just deal with in anticipation of reply. The second matter it concerns the reading of the supermajority provisions, both in Parliament and at a referendum, by reference to what might be called the denominator of the fraction. We submit, as you've seen in our written argument, that it is plain to demonstration, no room for contrary argument, that the expression at least 3/4 of the members of Parliament, like the expression 3/4 of the registered voters, has as its denomination the members of Parliament, as to its denominator the registered voters, meaning all or the total number of them respectively. I won't stay further in chief on that matter, but it is of course a matter of interpretation which is squarely before this court and which in our submission ought to be determined as we have written.
What do you say would be the effect of accepting that that interpretation advanced by Mr Butler is correct? It's a less wrenching way of making the amendment provisions work than the, I suppose, the brutality of the approach you adopt, which is to, as it were, sever them from the rest of the Constitution. So where does it get you? Say you can have a 3/4 majority calculated, it's really the referendum that's most significant, calculated by reference to those who vote rather than all who are eligible to vote.
Yes. Where would that get people who succeed in that argument?
Yes.
Well, nowhere for present purposes.
Funnily enough, I thought you might say that.
Yes. I think you've all seen our writing to that effect.
Yes.
It's tolerably obvious that section 160 simply doesn't provide any procedure, and no fiddling with how to interpret supermajority provisions will affect the fact of prohibition under 1592C.
Sorry, but say we construed the section in the way that Mr Butler contends for, you would have been one or two short in the House of a one, or I thought it was one, although I think you said two.
I think it's just over one, so it means you'd need two because I can't count a fractional vote.
Half an MP. The requirement to achieve 3/4 of those who vote in a referendum is obviously less demanding than the one that is.
Quite.
But would it really be practical?
No is the short answer. But may I make this clear? The supermajority provisions, however they interpreted, and the question relates to its interpretation, however they are interpreted, are not available for prohibited amendments, by which I mean amendments that may not be effected even following the procedure, however it is interpreted in section 160.
So the most relevant of those is the immunities, I guess, is it?
In what might be called a broader social political sense, yes. But our aim is at 1592C, because then Parliament can effect amendments of any provisions of the Constitution.
So do you say the immunities could be dispensed with?
If Parliament has the capacity to amend the Constitution, it has the capacity to remove the entrenchment in 1592A and B. So the answer is yes.
Okay.
Plainly enough, amnesties, acts of oblivion, immunities, non-justiciability, that cluster of provisions by which matters are kept from the court are matters of law. They have to do with the peace, welfare and good government of Fiji. They are within the scope of the constitutional responsibility of Parliament, subject to the Constitution. But for present purposes, the significance is that under 1592C, which is also entrenched, not by manner and form, but by simple prohibition, one simply doesn't get to employ a Section 160 procedure benevolently interpreted, if I can put it that way, or charitably interpreted, so as to reduce the formidable practical barrier. You would never get to that at all, because that which on the face of the bill was the target of Parliament's attention is simply prohibited by 1592C. Now, as you know,
doubly entrenched, is that right?
it's worse than double entrenched.
It is not, or it is?
It is worse than double entrenched. It is simply prohibited. And when I say prohibited, the Constitution says, and you can't alter that prohibition. So an entrenchment or double entrenchment is naturally a barrier, but it is always and has to be a barrier which can be overcome. Now, sometimes, as you've seen from the Cyprus decisions that the Commission has usefully drawn to attention, sometimes something which appears theoretically possible is nonetheless understood by constitutional judges not to be so, and indeed almost to wear the badge of, I dare you, this will never happen. And those are, in the Cypriot cases, those are examples of apparent manner and form, apparent usually double entrenchment, that doesn't pass constitutional muster because it prevents the exercise of democratic will ever. That is, it's not a matter of can you overcome the obstacles, it is a matter of the court saying these are obstacles designed in such a way that for all practical purposes, for a supreme law which must be given its meaning by consideration of its practical effects, cannot live with the democratic nature of such a constitution. Now, that's the experience in Cyprus.
The experience in Fiji has always been two-thirds. Why three-quarters on this occasion?
Well,
and there's no connection into other provisions of the Constitution to justify the use of that provision.
None at all. And this might be a good idea to remind you of what you've seen in the writing. Many members of the court are already well aware. The rather truncated way in which the 2013 Constitution was made included, by way of contrast, telling contrast, a highly deliberate process of consultation, commission inquiry, consideration and recommendations which were interrupted, purportedly abrogated, not able then to be implemented. But as you know from passages we've drawn to attention in our written submissions, the Yashkar Commission considered and recommended against a referendum. There hasn't been a referendum in this country, which is not a large country. Referendums cost a lot of money. Some might say parliaments do as well. But one might think that to add referendum to Parliament in terms of lawmaking is not something that ought to be done lightly. Certainly that was the recommendation by the widely consultative and carefully considered recommendations that would have led up to what I'll call a 2013 Constitution, but for the way in which it was interrupted. After those recommendations, there was a very truncated form of consultation in which, as you're aware, there were some protests uttered that a three-quarters referendum was just obviously intended as an obstacle. And so we submit. On its face, given that history, That is not there in order to ensure such a level of participation in an electorate. This is an electorate which one hopes will never produce absurd and offensive majorities such as one sees in other unfortunate countries like 98% turnout and 98% votes all one direction. In other words, this is a society which contains diverse views and where one expects to see an opposition in Parliament. And so in our submission, were we ever to get to it, and I don't want to spend any further time on it if I may, bearing in mind my limited time, it is clear that Section 160, in its purported imposition of a 3/4 supermajority, and frankly it wouldn't matter whether that was of those voting or of those eligible to vote, though it's plainly the latter on the proper interpretation of these provisions, that in our submission would answer the kind of description which, in accordance with the attractive jurisprudence in Cyprus on that point, ought to be seen as in fact a denial of the fundamentally critical, that is, the radically necessary legitimacy of democratic control of a constitution by the people for whom it is the constitution.
But may that then not go to the question of the extent to which the court accords recognition to the Constitution as the effective supreme law? Because if the language is intractable...
Yes. May I say, and with great respect, that could be another approach to achieve the same result as we seek to achieve. Can I explain?
Yeah.
And it really goes to the heart of the way we put it. You remember we start with the proposition, ugly but true, that this is not a constitution which in its origins, including what might be called its pre-promulgation construction, it is not democratic. It is not a product of the people's will in any way.
So just so I understand, are you referring to the decree that set out the non-negotiable provisions?
That's right.
Yep.
Well, not only the non-negotiable provisions, though that was a very signal part of the history, but also that there was not in any sense a use of existing, that is antecedent legal authority for the process of amendment by way of wholesale replacement. There was not a constituent assembly of any kind set up. There were procedures well in train which would have answered those descriptions, but they were interrupted, and one would, in our submission, be very unworldly indeed not to see that they were interrupted for a purpose, namely that they were perceived by those in power to be headed in a wrong direction. And we certainly say that that history and the way in which the Constitution was promulgated, following that brusque approach to the will of the people by those in power, means, as this court has suggested in quite another context, that there should be a grain of salt concerning what I'll call supremacy of constitutional provisions. Now, Justice French has asked a question which, with respect, suggests a parallel, not necessarily alternative, these could all operate together as arguments, way of reaching a view about the prohibition on amendment, which is right at the heart of the anti-democratic tyranny of those who made this constitution, tyranny of the, in the sense of the expression, the tyranny of the founding generation, over all succeeding generations of Fijians.
So I'm sorry, I've still got my mind stuck a little on immunities, which were also dealt with in Section 158.
Where, 159?
That's also 158.
158, yes. Well, that's right, under the little heading immunity entrenched.
Yes.
Yes.
So if you're right and the 2013 Constitution occupies all the constitutional ground, then the 1990 and 1997 constitutions are gone. So there are no immunities at all for the events that have happened since 1987?
No, I don't think that's true because of and I really don't have time to track them through in detail, but you will see that there are embedded in the 2013 Constitution continuations, explicit continuations of those immunities to which you have just referred, Justice Young, reaching back to the events of those.
So you would say, well, the immunities protect those who were involved in the events of 1987,
and earlier, yes.
But not those who were involved in the events of the early years of this century.
In fact, they do reach back, I think, almost completely, or I think completely comprehensively. They reproduce all immunities that have been made available.
But are they? I see. But they would be. You would say they're amendable.
No. Well,
can't go past 1970.
The short answer is yes, I do. But can I do it by a number of steps? You ask, do I say they would be amendable? Let me divide my answer into this. The Constitution says they're not, because they are contained in the cluster of cross-references to the past, which you will see in the provisions not only of Chapter 10, one of which you've just drawn to attention, Section 158, but also in Part D of Chapter 12. Yes. Those cluster of cross-references, which reach back to the past, provide, and I think the legal carpentry holds together, provide a comprehensive cloak of immunity, etc., amnesty and the like, no availability of remedies, etc., for all the events of the kind that your Lordship has referred to. Now, it is plain that Section 159, subsection 2, paragraphs A and B, have as their intention, which cannot be softened by any interpretation, that they can never be amended.
Yes, I agree.
Not by anything. Supermajority. That's why one can properly say they are provisions like the no amendment of the amendment provisions, paragraph C. They are provisions which it wouldn't matter whether every member of Parliament, all present and voting, it wouldn't matter whether every registered voter, let me exaggerate, every eligible person is registered. Every registered person does vote, and every registered person who votes, votes in favour. The Constitution purports to say that won't matter. You can't affect any of those. Now, these are all matters of law, and it is meta law of a significant kind to consider provisions for the amendment of a provision, paragraph C, hence the focus. The idea of taking from people the capacity to amend their own constitution when it is a constitution foisted on them not by any democratic, but given efficacy by history, by the passage of time, by it being unrealistic to go back. And could I just complete that as an aspect of my answer to Justice French? We obviously can only have one constitution operative at a time. Mostly, if I may put it ponderously, as lawyers we expect the last in time to be the only one that operates for fairly obvious reasons. That is only disproved in case of the total invalidation of the so-called last in time. In a contest between 1997 and 2013, there is an equality in their complete absence of antecedent legal authority for their promulgation. Neither was...
1997 was a democratically adopted constitution, though.
Depends what you mean by democratically adopted.
Well, both houses of Parliament adopted it unanimously.
That comes after its promulgation, if I may say so. It was promulgated by decree.
Well, what's the timing difference?
I'm not sure what the timing difference is, but it doesn't matter.
No. Well, I wasn't aware of that. I'm sorry.
There was no antecedent provision. There was no antecedent provision for amendment of the Constitution, which was used to bring it back.
I agree with that.
And that's the only point I'm making.
Sorry, I suppose in a way there was, because the Constitution was amended following a review process that did have its roots in the 1990 Constitution.
Indeed, yeah, absolutely. the Reeves Commission. We've referred to all of this history, including in the Statement of Constitutional Facts. But my point is this, that the 1997 Constitution had features a bicameral parliament, a divided electorate, which are enough in our submission to render unthinkable, unrealistic the return at one blow to the 1997 Constitution in Fiji today, particularly as there has been 3 elections intervening and laws made by the Parliament intervening. And it's in that sense that we submit that by recognition criteria, that the machinery for the peace, welfare and good government of Fiji, with 3 arms of government, under the 2013 Constitution, ought to be regarded as not merely efficacious, but appropriate to be recognised by this court in its so-called supra-constitutional function, as it happens under the 2013 Constitution. However, as Justice French raises, involved in consideration of that history and the terms of the Constitution, and in its interpretation and application, it is unavoidable that the court must look to certain of its features to detect whether there are impossible internal contradictions or inconsistencies. And let me make it clear, that's what we say is the character of 159 2C. Now, it's also of 2A and B, but 2C encompasses everything, because if you can amend the Constitution, then you can deal with matters which are inconsistent or contradictory or even an error, or even, in hindsight, best not done in the first place. In other words, the democratic control of a constitution by Parliament, who are the people's elected representatives, and controlled by the periodic elections which approve or encourage parties, governments to have behaved as they have in the past or say they will behave in the future. So that's the democratic control of the Constitution. And in our submission, as Justice French has said, there ought to be room for what I'm going to call, not disrespectfully I hope, a curate's egg approach to something which had the kind of unfortunate provenance as the 2013 Constitution. Good in parts, or perhaps more accurately, bad in some egregious parts, that can readily, without distortion, be removed because they are, in a familiar way, internal contradictions which require an interpreting court, to carry out the reconciliation or resolution of the inconsistencies.
Example of that is chapter 2, where it lists all this interesting list of rights, and in the second half take it off again.
So that in our submission is a result that can be reached either by what I'll call a limited recognition, that is recognising the 2013 Constitution, but not in the respects which are contradicted by it as a whole.
Well, it strikes me that rather than finding ourselves inside the 2013 Constitution as the starting point, and then responding to an invitation to, in effect, rewrite by interpretation those provisions.
No rewriting.
It sounds a little like that. It's perhaps more logically coherent and safer to say we look at this initially through the lens of the recognition process, having regard to what you identify as the democratic deficit of the 2013.
Yes.
And then look at the extent to which we accord recognition in relation to those particular provisions, and from that point on we move to the actual answering of the questions on the basis that we have jurisdiction because we've recognised the Constitution subject to those qualifications.
I understand what Your Honour says. Can I tackle, however,
yes.
I think not so by way of disagreement with the general thrust of what Your Lordship points out, but rather by saying we protest very seriously against the notion that we seek to rewrite anything. A court doesn't rewrite any instrument when by interpreting it, it says of certain of its provisions, well, they are ineffective or inoperative because they present impossible inconsistencies that must be resolved. And in civil private law, there's a whole repertoire of techniques, the general, the specific, etc., etc.
Have you ever tried that out in the High Court of Australia, Mr. Walker?
So what you're saying is it's slightly the reverse of the general and the specific, though, isn't it? You're saying it's the specific provisions of Section 160 that fail to meet the general provisions that imply a rule of law, a democracy, and self-determination for people.
I wasn't putting it quite that way, but with great respect, yes. That one way of putting it, one way of detecting how to resolve the inconsistency. And we've written this. I don't have time to go into all the detail, but you've seen all those provisions, and they start right up front, Clause 1, Section 1. You read all of them together. They are palpably regarded as governing and important and fundamental. Compared to the procedures, the manner and form provisions in Section 160, they are, in our submission, not capable themselves of being read down by interpretation. Democratic is democratic. Lawmaking by Parliament is lawmaking by Parliament. And it's not the will of people not in the electorate, and this Constitution doesn't have an expiry date, so it's made by people. It was made by people who, no doubt, ought to have regarded that their own mortality meant that unless something happened to it, that was going to govern people yet unborn when they came to vote. You can't vote for the amendment of this Constitution because of what these people put in Section 160. Now, we submit that is an impossible contradiction in terms within the Constitution, and not in some peripheral manner that doesn't matter, but in a way that presents this as an impossibly, that is undemocratically, rigid Constitution. A contradiction in terms, a law promulgated by one source of lawmaking, illegitimate as it was, which oddly says that all future legitimate sources of lawmaking are bound never to consider this topic.
Well, they have set hurdles for those who come after them that they were never prepared to go over themselves.
That's another way of putting it, and we would embrace it. But may I, however, again stress that what we are focusing on is not the amendments that simply face the hurdles of 160, which are not hurdles, they're impenetrable walls, and they're intended to be. But we're not focusing on that principally. We're focusing on the one where, regardless of however many people, wherever supported an amendment, this Constitution purports to say it can't be done. Now, we do embrace the notion that that is an element of the Constitution which doesn't call for recognition in the sense of efficacy, in the sense of deriving legitimacy by providing a monopoly of the source of administration of a society for an appreciable period, all of which could be called in aid generally for the 2013 Constitution, but certainly not for these obnoxious features which contradict in a way that cannot be reconciled by shaving off this, polishing that, concerning the democratic features of the Constitution.
Isn't the problem, though, that the approach the state is contending for reduces the Constitution to just another piece of legislation?
Now, that is a very important aspect of the matter. May I come directly to it? If one considers the important provisions which are found in a constitution which, but for its obnoxious features, would we expect receive acclaim quite widely. If you considered, for example, the provisions of Section 97 of a familiar kind in Chapter 5 for the Judiciary, but in particular Chapter 2, this being a constitution which constitutionalised matters which at one level are the subject of international conventions and at another level can be the subject of merely municipal legislation. those are matters which the history of this country shows in previous constitutions attracted differential supermajorities, and for good reason. A safeguard, but not a bar, on the expression of things which are headed Bill of Rights or the independence of the judiciary is commonly understood to guard against what I'm going to call the inadvertent implied repeal by a simple statute of such important constitutional guarantees. As you know, techniques have been attempted in other constitutions requiring that an amendment, and echoed in this constitution, that an amendment not be effected except by a bill that explicitly, that is, in terms, by actual words, says this is to amend the constitution. Unfortunately, the court will be aware of constitutional arguments in other places and other times where the court says, alas, I have to interpret the latest statute. And the latest statute means what it says, regardless of the fact that there is a manner and form provision previously purporting to prevent it from having that effect. Now, those are arguments that are best avoided, surely, and it is for those reasons that there is familiarly supermajorities for amendment. But as we've drawn to attention in our written submission, there is a history in this country of, in general terms, apart from special provisions, bills of rights, but also certain
Land
personages.
Particularly land rights.
Absolutely. So I call it peculiarly and important Fijian matters of social history. But the general rule otherwise was, by repeated promulgation, was 2/3 in the House. Now, you will have noticed that I'm appearing on the instructions of a cabinet responsible for introducing a bill which would stipulate just that. So, with respect, it is correct that if nothing were done as is proposed to be done by the bill, upon removing either by non-recognition or by interpreting and applying the Constitution so as to render inoperative and ineffective its impossible internal contradiction constituted by a prohibition against amending its own amendment provisions, either way, upon that occurring, unless there be the requirement for 2/3, then the way will be open, obviously, that for the organ of lawmaking, the Parliament, to amend the Supreme Law by a simple majority. Now, it may be that the people would like that. That's a matter for the people, not for this court. That is, it's not a constitutional doctrine, justiciable and subject to mandate by this court, compulsion by this court, that there be any supermajority or of any particular size. The people were never consulted about supermajority. Their government, that is, the government with the support of the Parliament they've last elected, has proposed in the bill in question that there be a 2/3 majority, familiar in Fijian history. And there is no problem about the bill itself only having got over the line by a simple majority. It got over the line by a very large majority.
All going, it's sort of, is in a sense, elaboration of a point that I think is essentially that absent sections 159 and 160, amendment goes by default to being able to be affected by an Act of Parliament.
I think that must be so because lawmaking is for Parliament. Now, it's not for this court to say that would be a pity, even though everyone in court might say, well, it is a pity. Certainly, I here represent a government who says it should be 2/3, as it was for the general run of cases in the past. And success for our argument will lead, of course, I expect, to the government being close consideration to simply presenting this bill without a referendum to the President for assent, upon which there will be a simple, orthodox, attractive 2/3 majority in Parliament for constitutional amendment. Now, that is, in our submission, the way through we don't spurn, with great respect, the idea of eliminating 1592C by lack of recognition incorporating it, as Justice French has proposed. It produces the same outcome as the interpretive resolution of a textual crux constituted by an internal self-contradiction between the manifestly leading and fundamental criteria of democracy and rule of law and equality of individuals and the dignity of the person, to which we've referred in our written submissions, and denying the current and all future generations any capacity to amend the amendment provisions and indeed to amend other provisions as well. Once you may amend the amendment provisions, then of course you can open the door to any particular manner and form procedure that might be made by then legitimate constitutional amendment to, for example, the provisions contained within or referred to by paragraphs 159, 2A and B. And that is, in our submission, the means by which an argument which necessarily, as Justice Young has pointed out, involves as a step, well, if you remove 1592C, there is no other provision permitting amendment of the amendment provisions because the only provision was to prohibit it. Is there a gap? Well, no, there's not a gap because this is a country with three arms of government and it's to be understood as a constitution, not as a trap. And so obviously the lawmaking of Parliament extends to whatever is required from time to time by the judgment of the members elected according to the judgment of the electors. And obviously enough, the terms of the Supreme Law are part of the business of Parliament. Apart from the dead letter 161, even this constitution recognises that for all but certain provisions, there may be amendment by two organs of the state, one, the Parliament, and two, the people at referendum. So saying that Parliament can amend the Constitution is in itself unremarkable in Fijian political history because that's always been the case hitherto. No referendum requirement previously.
There were two houses, though.
Absolutely. And if I may say so, it's not just simple two houses. There are also
The Great Council of Chiefs.
The Great Council and classes of appointees, etc., etc. So there was, that's one of the reasons why one really can't go back to recapture all of that. But my point is this, it was Parliament, which was the constitutional amending organ in the past, a familiar proposition to countries. Not everyone goes through the agonies required in Australia. And supermajority is familiar as a matter of comparative political science with which your honours are familiar, which of course familiar. It's a very familiar way of, as it were, ensuring that simple legislation will not have inconvenient, perhaps even unintended effects of altering the Constitution. But it doesn't mean that you can't do it by legislation. That's why it is so significant that the bill that has produced this reference, arrested as it were in its passage because of the failure for want of 2 votes, is such an opportunity. You appreciate, of course, that if we had got those 2 votes and it had gone to a referendum, of course there would be people who would say, including the government on a proper understanding of the Constitution, it doesn't have to go to a referendum because a Section 160 simply doesn't apply to this kind of amendment. This is an amendment of an amendment provision. That is not a permitted amendment under 1591. And for those reasons, you simply have not a gap, but an instance of lawmaking fitting within the general lawmaking competence of Parliament. And with great respect, the legitimate, well-founded concern of a constitutionalist, particularly with comparative experience, other times and places, that our argument seems to be an argument for, that is, in favour of constitutional amendment by simple legislation, simple majority legislation, really doesn't represent the true position. We don't embrace that as the proper way in which, for Fiji, by my client's legislative judgment, we don't embrace that as the proper way. We have said, let's go back to the historical norm of 2/3 in the Parliament. And in this case, it would be a Parliament which, by reason of a very much better dealing with questions of equality between citizens and voters than in the past, will be a more genuinely democratic outcome in terms of constitutional endorsement than has occurred previously in this country. The fact that we say Parliament can do what it did does not therefore threaten, on the facts presented in this reference, with this bill sitting in limbo at the moment, 40 out of 55, it does not threaten the spectre of constitutional amendment in the future by simple legislation, because once it becomes effective, it'll be back to the, I was about to say good old days, that would not be right, back to the former measure, which in general applied, of 2/3. Now, I'm conscious that I'm probably 3 minutes over time. There's a deal else to say, but we have certainly written everything we want to put before you, including in our reply submissions. May I simply respectfully request that the court give consideration to allowing me to address in reply if there are matters that arise during the interveners and amicus submissions that I don't think I've done full justice to on behalf of my client in my address.
You'll be given time to reply later.
Please.
So, what do we... We'll take a 10 to 15 minutes break and then we'll resume. And then the next one will make the submission, 40 minutes. All right, thank you.